Lesson: Exclusion and Limitation Clauses. Exclusion and limitation clauses are critical components of contractual terms, serving as tools that manage risk and define the boundaries of liability between contracting parties. These clauses, when effectively drafted and appropriately implemented, can significantly mitigate potential disputes and financial losses. However, their enforceability and effectiveness are contingent upon a thorough understanding of their legal foundations, proper construction, and strategic application within the framework of contract law. Exclusion clauses serve to restrict or eliminate liability for certain breaches of contract or tortious acts. Limitation clauses, on the other hand, cap the extent of liability to a specified amount. Both types of clauses require careful consideration and precise language to ensure they are enforceable. Courts scrutinize these clauses, especially when they are perceived to be unfair or ambiguous. Therefore, the drafting of exclusion and limitation clauses must reflect clarity, specificity, and fairness. One practical framework for drafting these clauses is the Four Corners Rule, which emphasizes clarity within the contract's text. Clarity is paramount. Any ambiguity in exclusion or limitation clauses is often interpreted against the party seeking to rely on them, as per the contra pro forentum rule. Thus, ensuring the language is unambiguous and directly addresses the scope of liability is crucial. For example, a clause that simply states, "We are not liable for any damages," may be too vague. A more effective clause might specify, "We limit our liability for any direct damages arising from the breach of this contract to $10,000. Another critical tool is the reasonableness test, derived from the Unfair Contract Terms Act 1977 in the UK, which dictates that exclusion and limitation clauses must be reasonable. The test considers factors such as the bargaining positions of the parties, whether the customer received an inducement to agree to the term, and whether the customer knew or ought to have known of the existence and extent of the term. For instance, in the case of George Mitchell Ltd v. Finney Lock Seeds Ltd, 1983-2 AC 803, the House of Lords held that a limitation clause was unreasonable because the seller could have easily insured against the risk. This case illustrates the importance of ensuring that limitation clauses are not only clear but also fair and justifiable. Professionals must also consider the incorporation doctrine, which requires that exclusion and limitation clauses be properly incorporated into the contract. This can be achieved through signature, notice, or a course of dealing. The case of Parker v. Southeastern Railway Co. 2, CPD 416, highlights the necessity of providing sufficient notice of such clauses. Parker, having left his bag at a cloakroom, received a ticket that included an exclusion clause on the back. The court ruled that reasonable notice of the clause must be given for it to be enforceable. This underscores the practical step of ensuring that such clauses are prominently displayed, communicated, and acknowledged by the parties involved. Furthermore, professionals should employ the consistency principle, ensuring that exclusion and limitation clauses are consistent with other contractual terms and not rendered redundant by any overarching statutory provisions or common law duties. For example, a clause that excludes liability for gross negligence may be inconsistent with statutory duties of care and therefore unenforceable. Legal professionals should also regularly review and update these clauses to align with current laws and judicial interpretations. In implementing these clauses, risk assessment is a vital step. Identifying potential risks and evaluating their impact on the contract can guide the inclusion and scope of exclusion and limitation clauses. This is particularly relevant in industries with inherent risks, such as construction or technology sectors. The process involves anticipating potential breaches and drafting clauses that address these specific risks without overreaching, which could render them unenforceable. A case study exemplifying the strategic use of exclusion and limitation clauses is Photo Production Ltd v. Securicor Transport Ltd, 1980 AC 827. In this case, a security company was contracted to provide services, and the contract included a clause excluding liability for any damage caused by their employees. When a security guard caused a fire that destroyed a factory, the exclusion clause was upheld by the House of Lords, as it was deemed clear and part of the contractual bargain. This case illustrates how well-drafted clauses can effectively shield businesses from significant liabilities. Statistics further emphasize the importance of these clauses. A study by the International Association for Contract and Commercial Management reported that poorly drafted exclusion and limitation clauses are among the top causes of contract disputes, with 30% of disputes arising from ambiguous terms. This statistic highlights the necessity for precision and clarity in drafting effective exclusion and limitation clauses. To enhance proficiency in this area, professionals should engage in continuous learning and practical application of these principles. Workshops, seminars, and training courses focused on contract law can provide real-world scenarios and solutions. Legal practitioners can also benefit from peer reviews and feedback sessions to refine their drafting skills and ensure compliance with legal standards. In conclusion, exclusion and limitation clauses are indispensable tools in contract law, offering protection against unforeseen liabilities. Their effectiveness hinges on their clarity, reasonableness, proper incorporation, and consistency with other contractual and legal obligations. By employing frameworks such as the Four Corners Rule, reasonableness test, and incorporation doctrine, professionals can craft enforceable and fair clauses. Continuous education and practical application of these principles are essential for mastering the intricacies of exclusion and limitation clauses, ultimately leading to more robust and resilient contractual agreements.